It's my pleasure to introduce this panel on the Supreme Court of North Carolina, where I had the honor of clerking a year or two back for Justice Barringer. So our moderator for this panel is Judge Numbers, who you've already seen a couple times this afternoon. Judge Numbers serves as a United States Magistrate Judge in the United States District Court for the Eastern District of North Carolina. A graduate of Notre Dame Law, Judge Numbers is an originalist scholar who has led the charge on moving originalism from theory to practice. Joining us on the panel, we have Ray Starling, who is the General Counsel of the NC Chamber and President of the NC Chamber Legal Institute. In that role, Ray sets the litigation strategy for the NC Chamber, directing the filing of influential amicus briefs at the state Supreme Court, and leads the Chamber's public policy development efforts. We also have Nick Broad joining us. He is the Deputy Solicitor General in the North Carolina Department of Justice, where he represents the state in high-profile appellate litigation before state and federal courts. Nick also teaches appellate practice at Duke Law. Martin Warf is here as well, a partner in the Raleigh office of Nelson Mullins, where he focuses on business and consumer financial services litigation. A Campbell Law graduate, Martin's practice often brings him before our state's highest court. And finally, we have Troy Shelton, a partner in the Raleigh office of Fox Rothschild, a board-certified appellate specialist. He handles appeals throughout the country with a focus on North Carolina. He also pens a monthly column on appellate-related news for North Carolina Lawyers Weekly. Please join me in welcoming them.
Thank you, Nate, for that kind introduction. It's an honor to be here today to moderate this panel with these experts on the Supreme Court of North Carolina. It's been a noteworthy few months for the state's highest court. The court welcomed 2 new justices at the start of the year, and since then it's decided several cases that have engendered substantial and passionate debates both within and without the court about the court's role, the permanency of its earlier decisions, and the appropriate methods of judicial interpretation. Today, we'll hear from our experts on the cases that the Supreme Court has reconsidered earlier this year, prominent cases currently on the court's docket, and noteworthy cases that'll be coming in the next few months. My role is largely to stay out of the way, so at this point, I'll turn everything over to our first speaker, Martin Warf.
Everybody, thank you for your time and attention. I think I drew the short straw that fell on the floor and then broke about discussing the 2 cases that have been recently reconsidered from decisions in December and then reconsidered and opinions published in April. I'm sure everybody knows what those cases are, so if I get something wrong, please shout it out. But they are the cases on redistricting and voter ID. And so it's not a redistricting panel or a voter ID panel, but I do want to talk about how kind of both of those cases got started and then where they ended up with the Supreme Court. So most cases, for all the lawyers in here, I think you would say that most cases take years to finish. But the redistricting case went from the enactment of the law to being tried to being appealed 2 to 3 times to the North Carolina Supreme Court and to the Supreme Court of the United States in 7 months. So that was a really fast case, and certainly on the rare side of what you would see. In addition to being rare in time, it also featured certain rare procedures. For example, when the preliminary injunction for redistricting was denied by the 3-judge panel, it was appealed to the Court of Appeals that reversed that decision and entered an injunction, and then that decision was reviewed en banc by the Court of Appeals and reversed again. So I believe that remains the only en banc review by the Court of Appeals, which was done without oral argument in this particular case. Once the case got to the Supreme Court, which was done by a PDR, and I don't want to over-explain anything. There are a lot of great appellate lawyers in here, but a PDR is a petition for discretionary review by the Supreme Court, and you can do that after the Court of Appeals, or you can do it before the Court of Appeals has made a decision. it is on the rarer side of things to have a case taken up by the Supreme Court of North Carolina before the Court of Appeals enters its final decision. But this case was one of those that was granted and went up to the Supreme Court. The Supreme Court entered, again, another rare order, which I think you would see more in the federal system, where you have an order coming out and then an opinion to follow. But the Supreme Court entered an order on February 4 that reversed the trial court and enjoined the maps that were enacted as partisan gerrymandered maps. It also set forth a trial schedule and pushed the primary dates and did a couple other things. The opinion that was then issued on February 14th went a little bit further and in its explanation, and held that the question that was before the court was not a political question. Whether there was partisan gerrymandering was not a political question, which was the opposite of what the Supreme Court of the United States had held earlier. So you had that set up, and then you had then a remand for additional review and trial. And in the Supreme Court opinion, again, this is not a redistricting panel, but I'll just give you, there were some metrics that were discussed in the opinion to determine whether a map might be presumptively constitutional. And that phrase, presumptively constitutional, is a running theme, I think, from probably what we will all discuss, but it is a theme of how the court looks at a particular law as being passed by the General Assembly as presumed constitutional, and then therefore challenged in the court. That presumption of constitutionality is something that I think the court went back and forth about during this time period. But you do have a situation where the trial court was re-engaged to evaluate new maps, and those maps were new maps that were passed by the General Assembly. Special masters were appointed for the three-judge panel, and then those special masters hired their own special masters to actually crunch the numbers, because why I'm not all that good at redistricting is because it involves a lot of math, and I did not go to law school to become a mathematician. But those special masters did, and so there's a lot of math discussion in a redistricting opinion, and where you're talking about means and medians and how the districts compare to one another, and excess votes or efficiency gaps that might be needed to sway a particular district one way or another. So once you had a decision by the trial court, there was enough in that decision that every single party found something they did not like about it. So everybody appealed to the North Carolina Supreme Court, which is interesting because, again, an appeal would normally travel from a trial court to the Court of Appeals, where that would complete its run, and then it would go to the Supreme Court. But based on the prior orders of the Supreme Court, the case was to return to the Supreme Court instead of going to the Court of Appeals. So the Supreme Court then issued its opinion and determined that the maps were unconstitutional. And all three maps, the congressional map, the state house map, and the state senate map. The decision tree at that point, again, involves, both of these cases involve both federal action and state action. So in this particular case, not only was there continued legal action in the state court, but there was also legal action in the Supreme Court of the United States, where the leadership of both committees that drew the maps appealed part of the decision regarding the constitutionality of the congressional map to the Supreme Court of the United States. And they did that under the basis that the federal Constitution has the elections clause, which says that the state legislature shall be in charge of the time, manner, and place of elections. So there was a federal hook, at least for the congressional map, but not necessarily for the state House and state Senate maps. So at some point in this case, the parties that litigated it were waiting for a decision from potentially the trial court as far as scheduling, the Supreme Court, and the Supreme Court of the United States, which is certainly rare to say that you'd be waiting on something at the same time from 3 different courts. The Supreme Court of the United States did not grant a stay, but 4 justices noted that they would be inclined to grant certiorari over the decision. And so I'll come back to that. But once that decision was made, you fast forward a couple months, and then while the matter was on appeal at the North Carolina Supreme Court, the General Assembly moved to dismiss its own appeal from that prior order of the trial court relating to the congressional maps. Normally, when you file a motion to dismiss an appeal with an appellate court, the answer is, by all means, thank you for not letting us have to decide this case. This one had a rare decision. In a 4-3 decision, the Supreme Court denied the motion to dismiss and elected to keep the decision, keep its court involved in that particular decision on the congressional maps. There was some, obviously, dissent. It was a 4-3 decision, and both sides, I think both parties were accusing the other party of procedural chess, as it became known in the gamesmanship of which court would be better for them to decide a particular issue. But you had that going on at the same time. So everything was argued in October of 2022, and on December 16 of 2022, the opinion in the redistricting case was issued by the North Carolina Supreme Court. It affirms the unconstitutionality of the congressional plan, or it did affirm. It affirmed the constitutionality of the state House plan, but reversed the trial court's decision on the North Carolina Senate plan, finding it unconstitutional. The court noted that in its earlier opinion, referred to as Harper 1, that it was not necessarily describing a single metric or a group of metrics that would be used to determine whether a map was particularly or overly partisan into its sense that it was partisanly gerrymandered. But the trial court says the trial court could have gauged other analysis as it did in its first trial. So with that issue being decided on December 16th, you might say, well, how did it get back to the Supreme Court again? And therein lies a rule of appellate procedure known as a petition for rehearing. It's not a new rule. It's been there the entire time, and it allows for a litigant to petition the court that just heard the matter to rehear it, and if the petitioner believes that there are mistakes of law or mistakes of fact that were included in the opinion as the basis for the rationale of the court. We often try to think of rehearing things at the state court, like the trial court level, but you don't often think of that being a rule in the appellate courts, but it is. And the timing for that rule is that you may file your petition within 15 days of the mandate of an opinion being issued. Without any order of the Supreme Court, a mandate issues within 20 days after the opinion has been filed. So you can see that in December of 2022, as been noted, the court changed hands and a new group of justices were going to be in the majority come January 1. So when the petition for rehearing was filed, it was filed to a different majority of justices than existed, but it was a very clean application of the rules of appellate procedure. So when the petition was filed, it was filed around January 15th or so, and the court accepted the petition for rehearing and then entered its decision in April of 2023 that determined that the case was really more of a political question, and based on several reasons within that decision, the court withdrew the prior opinion and overruled Harper v. 1. And so I think to me, a substance, if you don't even look at redistricting as a substance, one of the substances that came out of that case was, to me, the political question doctrine in North Carolina. And before this case, I would say the political question doctrine was probably like that picture of Marty McFly in Back to the Future that's just slowly disappearing as he's standing there next to the well. And there had been several opinions that had challenged on the idea that a case was not necessarily a appropriate case for the courts to decide, but the court had decided it and noted that the political question doctrine was fairly weak or minuscule in North Carolina. This case, I think, revived that position to say, hey, there are things that the court should not necessarily be involved with, and for these specific reasons, we believe that the General Assembly has the authority within the text of the Constitution to issue redistricting decisions, to draw new maps. But to touch back on the issue for the Supreme Court of the United States, they did end up through 2 rounds of briefing determining that the matter was not moot, but nonetheless still issuing an opinion. And the opinion there, with the challenge to that legislation, was that under the Federal Elections Clause, did the court, was there such a thing as an independent state legislature theory? Could the state legislature draw their maps without interference from a court? And the Supreme Court of the United States said no, that was sort of a bridge too far, and that they were subject to being adjudicated like any other law, quite frankly, under the Constitution of the various states of the United States or the federal Constitution. So I'm going to spend less time on the voter ID, but just to tell you that it had some very similar issues with it. You had, again, a petition for discretionary review prior to a decision of the Court of Appeals being granted. You had an order for expedited briefing coming in, and you had the case which was both going on in the state court and the federal court at the same time. So you had federal decisions that played into a role, and you had state court appellate decisions that played into a role. You also had the North Carolina Supreme Court issuing its opinion on the matter on the same day in December that it did the redistricting opinion. So once again, the litigants there used the rules of appellate procedure without what's called using Rule 2, which means that you're going to do something outside of the rules. You just apply the rules of civil procedure or appellate procedure, and you file your petition for rehearing. The court agreed to grant that petition for rehearing, and then in April also issued its decision withdrawing the prior opinion of the North Carolina Supreme Court holding the voter ID law itself to be unconstitutional, and found that that law was not unconstitutional. And I guess I'll express to close that's a pet peeve of mine when people say the court found the law to be constitutional. Well, the court really doesn't find laws to be constitutional. The question is whether it is unconstitutional or not. So I like to say that they found it not unconstitutional, and because it was constitutional to begin with in the first place. So I think that comes from my deference to the legislature and that notion that I started with of what it means to have a presumption of constitutionality.
Thanks, Martin. Ray, we'll hear about some interesting cases right now.
I thought there was another warm-up act before us.
no,
I need to be on my toes. Speaking of toes, it rhymes with toes, but you probably haven't even noticed. But I feel like we ought to get this out of the way, that there's something on my face. And my joke has been over the last 4 weeks, I only have 3 more weeks to go, you should see the other girl. And of course, that's funny because the women think that joke's great, and the men are all like, Can we laugh? Can we laugh at that? And then they see the women laugh and they can laugh. And you really should see the other girl. She wears a white coat and she loves lawyers with bad skin genetics and high deductible insurance plans. So I feel fortunate to be a part of this group to represent the NC Chamber Legal Institute on this panel. I will say what's going through my head is talking about cases in retrospect from 22 and 23. Trying to say, here's what I think is important about what the court said, and knowing that there are members of the court in the room, and one of my board members, and the counsel to the speaker, and the counsel to the pro tem, and the chief of staff to the pro. What could possibly go wrong, right? So I'll get my resume ready to be a paralegal somewhere, depending on how this goes. I felt like when I walked in, I'd already missed the mark, but just think through this with me. I do have my tie on. It just happens to be wrapped around my nose. So in terms of what Nick and I, and we're sort of sharing a little bit of time here, what we hope to accomplish in our time is doing that retrospective review of just a few cases. And we won't do a case-by-case rundown, but we sort of grouped 2 or 3 things thematically. And I won our coin toss, so I get to be on offense first. And so really sort of 3 big picture observations of cases over the course of the last 24 months or so. 1, a conversation about administrative deference. Is it or isn't it? And I recognize there was a panel on that this morning. I missed the Jeanette Doran, William McKinney battle. I would have loved to have seen Jeanette put William in a headlock, but I missed that. Secondly, the way the court attends or seems to be poised to attend with what I call the strictures of statutory liability schemes. I will use a couple of workers' compensation cases to make the point there. And then third, we've seen it now pop up a couple of times, personal jurisdiction cases for out-of-state corporations. So if you're keeping notes, and I hope you're not, but let's start with Roman number 1, administrative deference. And given that conversation earlier today and the fact that as the U.S. Supreme Court has started its term, with a case on the docket about Chevron, I don't feel like I need to do a ton of review there of what administrative deference is. It is harder than it sounds, and I think there's some interesting history there, including the fact that NRDC actually lost the case. Chevron actually won the case, and so over a period now of several decades, the advocacy organization lost that war, but then ended up figuring out how to use administrative deference to its advantage over the course of the last few decades. So I just think that's an interesting observation at the national level or federal level. Maybe one more is that folks like Justice Gorsuch actually think administrative deference is already gone and long gone, but the lower courts just haven't gotten the point. And he would even be, I think, so bold to say part of that is because of the work it takes to write the opinion to overturn the agency. It is much easier to sort of move things along. Now, why do I think that's important? Let me be clear here, and some of you will get the sense of humor of this. To the extent that any administrative law challenge in state court in North Carolina has come through the North Carolina Office of Administrative Hearings, I don't think we have a big agency deference problem here at the moment. If you're not watching the tenor and scope of agency deference cases at the OAH, then I think you are missing some entertaining reading. And if you were entertained by Judge Vandervaart earlier today, you would be entertained by his prose in some of those cases. And so the natural question is, okay, fair enough, Ray, enough stage setting, but how does that relate to the Supreme Court? What's happening in the Supreme Court? And again, just one more caveat. I read this in a book one time. A guy said, I get the idea that people don't agree with me and they think my ideas are stupid. And I get that idea because people come up to me afterwards and say, I don't agree with you and I think your ideas are stupid. So there will be time afterwards for you to come up to me and say that. But I think the best proof that we have a little bit of a live conversation going on around this topic in some cases is frankly what the justices have said themselves. I want to mention a Utilities Commission case. And I think of the Utilities Commission, administrative agency. I'm sort of lumping those together perhaps sloppily. But in a January 5th, 2022 case, so this would be a post-election case, actually, I guess that's not right. That was well before the election of 22. Just to clarify, January 5th was well before the election of 22. But I mention it partly because Utilities Commission cases are awful and probably don't get mentioned in many places unless someone brings them up. So Irvin writing the majority, joined by Earls, Hudson, and Morgan. So this was a 4-3 case. Justice Berenger writing the dissent, joined by Justices Newby and Berger. The central issue in the case related to recovery cost, the utility's ability to recover costs from ratepayers for coal ash remediation. And so a number of utilities in the state had gone through that process. Dominion, or in this, I think they're called Virginia Electric Power in this particular case, they're before the court appealing something from the Industrial Commission. And really what Justice Berenger is pointing out is that the Utilities Commission had allowed one recovery period for one ratepayer and now seem to be enforcing a different recovery period for a similarly situated ratepayer that just happened to be in a different case. And of course, at the end of the day, the utility wants to recover that outlay from ratepayers as quickly as it can. If I offer to pay you back over 10 years versus 5, you would not take that deal. And so you don't really need to understand a lot about utility law to understand what Justice Berenger says in her dissent. And I want to quote her. Now remember, this is 22, so Berenger's dissenting. The issue I address today is whether the Utilities Commission needed to explain why it departed from its reasoning in 2 cases that were decided less than 2 years prior, had materially similar facts, and were brought to the Commission's attention. ... Under general tenets of administrative law, an agency's failure to explain a departure from recent applicable past decisions when they were brought to its attention is arbitrary and capricious. And so she would have remanded this case back just for that kind of consideration. Talk to me about why you're treating these 2 ratepayers, or these 2 rate setters, if you will, sort of differently. Justice Berenger, along with Justice Newby and Berger, absolutely left the door open, or would have, had their opinion been the majority, for the Commission to explain why it did what it did, but agreed that its failure to do so in this case was a fatal flaw requiring reconsideration. Now, I set that up because fast forward to last month, it's now September of 2023, when Justice Berenger is writing for a majority of the court in a DEQ case. And without getting into the facts of that case, there's now what I think will become in North Carolina Supreme Court law a famous footnote, kind of like the Caroline Products footnote 4 back in the 1930s. I want you to go read Sound Rivers footnote 6. And if I may, I think there's a lot happening in the footnotes in that case, but it just so happened that the majority opinion was only 10 pages long. The dissent, written by Justice Earls, was 25 pages long. I think she might not have liked the original ALJ in the case, whose name happens to rhyme with Berger. He was, by the way, recused in this case, but here's Justice Berenger, footnote 6 on page 10. Nothing in our opinion should be understood to give the division deference, the Division of Environmental Quality, to give them deference in its interpretation of the regulation. Then it goes on. And I can hear Justice Berenger as I read this. On 14 separate occasions, the dissent mischaracterizes our analysis as deferring to the agency's legal interpretation. We have not. Constrained by our constitutional duty to apply the rule of law and to comply with the legal standard of review, we review whether the ALJ's interpretations are consistent with the law. The ALJ performed its own plain language analysis, which happened to match the division's interpretation in this case. So it seems to me like, we don't use all caps in Supreme Court cases, but it seems like what they wanted to say was, we are not deferring to the administrative agency here, and stop saying that's what we're doing. I just don't think, and I again could be wrong, I don't think you can, think about it. For how many people in this room have clerked, you know there is no random language in a decision, right? You have read it. Your fellow law clerk has read it. All the justices on the court have read it. There's people that get paid to read it coming behind you and to make sure it makes sense and that it's footnoted properly and the citations are correct. It is not an accident that this language is in here. And so I don't think you can look at that and not conclude that the court is being pretty darn attentive to how much deference it gives an administrative agency. There's a great Campbell Law Review article out a few years ago by Professor Hessick, one of my colleagues at UNC Chapel Hill. I can't really call him a colleague. I'm just a lowly adjunct, but he's the real deal. I think he actually advises the Federalist Society over there. And he points out there's sort of these two different driving reasons for this administrative deference. One of them is the agency may have expertise. I don't think that's going to be that convincing here. But the second is, uniformity, to make sure the law is actually applied over and over the same way. So I'm going to go out on a limb and kind of conclude it's the uniformity piece here that could save the day. And all that to say, and as I understand it, this may have been covered this morning, I actually think there's a lot of confusion in our written cases about whether we're a Chevron state or not. The Court of Appeals seems to be very convinced. The Supreme Court seems to be more skeptical, more like we're a Skidmore state. But all that to say, your free giveaway is watch these administrative deference cases. Roman numeral 2. Let's touch on workers' compensation. Because, Federalist Society conferences are known for deep dives into workers' compensation law. I'll set the stage here by just saying there is a reason, and one of the guys that worked on it is sitting over to my right. There's a reason that I think there's a more heated debate among the plaintiff bar and the insurance bar about workers' comp at the moment. And part of that comes from the fact that the law was rewritten quite a bit back at the early part of the last decade. And some of the cases and fact patterns that arise from those rewrites are just now getting to the court. Second, I frankly think the plaintiff's bar has gotten more and more creative as they've tried to undo perhaps some of the benefits of the bargain that the insurers got back when the General Assembly rewrote the workers' comp law in 2011 and 2012. So one case in particular worth mentioning is Cunningham versus Goodyear Tire. That was a 22 case. So the majority was written by Hudson. Newby and Behringer dissented. Berger did not participate. And I'll sort of skip ahead to say Justice Hudson, who I believe is the only, or was at the time, the only justice on the court that had a workers' comp practice before coming there. She agreed with Judge Chris Burke in the Court of Appeals, and we ended up with a new rule, a new statewide rule, that if you can couch a time limitation as a jurisdictional issue, you all of a sudden get de novo review of that jurisdictional issue, and you get to take the case back to the commission again for another bite at the apple. On this one, I want to quote Justice Newby. He was having none of this, and he, I believe, correctly wrote, jurisdiction rests upon the law and the law alone. It is never dependent upon the conduct of the parties, and whether a party timely filed is not a jurisdictional question. My favorite part, though, and I think this goes to part of the kinsmanship in this room. Are we out of time?
No.
Is that him? Is he coming? Though, man, that's really disturbing. I think that's worse than having your nose carved on. Though the majority claims their approach is consistent, seriously, time out here. This is heart-to-heart conservative teaching here in these two sentences. Though the majority claims their approach is consistent with the Act's legislative purpose, because if you can get the result by saying, oh yeah, this is generally what the law requires, of providing compensation for injured employees, let's stop there. Is the workers' comp law's general purpose to provide for injured employees? It is not always that. It could work to actually hinder the very purpose the majority seems to want it to affect. Quote, broadening appellate judicial authority to allow a de novo fact finding brings increased uncertainty to the process. I can almost hear him say to the majority, be careful what you wish for. You better go with the commission as your fact finder as opposed to looking for ways to get the appellate courts involved in it too. So I think that case fits. There is at least one more we could talk about where I feel like the court now is more poised to say, hey, let's look at the strict language of the statute. Let's don't think about all this, quote, big picture intent. Let's not worry that much about the end result on this particular party at the end of the day. Maybe the best example, West versus Hoyles Tire and Axle. Hoyles Tire, by the way, is up north of Raleigh. in what some of you may call Henderson, but you would be inaccurate because it's Henderson, up in Henderson. Mr. West had a, quote, alleged cohabitating fiancé. And under the workers' comp law, if you have an alleged cohabitating fiancé, that person is not allowed to take under the statute. And so the dissent, I think, really wanted to change that in this case. But Justice Newby points out, look, this is settled. It's been settled for 70 years. And essentially, if the General Assembly wants to change it, they know how to change it. So see conversation about the branch of the government that represents the people. In her dissent, Justice Hudson obviously disagreed with Justice Newby and the 4 other justices in the majority, including Irvin and Morgan. But she went on to say, you know, times have changed, and we ought to treat this as another body inside the same household. It's reminiscent of a case, frankly, the court decided a couple of years ago in an insurance coverage case where a separate home on like a separate farmhouse or a guest house, the injured was trying to reach in and get the underinsured motorist coverage as a separate cap by saying that this person was in the same household as opposed to a separate household. So I think we can pay attention to the court sort of guarding the strictures of these statutory liability shifting type regimes in the state, and that was just another observation. And then very quickly, the personal jurisdiction cases, at least 2 that are notable, Toshiba and LG Chem. In both of those, the court, I think, recognized 2 things about the state, that the minimal contacts test obviously is encountering a new economic society in North Carolina where we have a growing economy and a lot more presence of folks coming in and out of the state to do business. In one of those cases, they sent it back down for more fact-finding, and in the other, Justice Beringer said, look, the minimum contact test has been met. And if I had throwaway comments at the end, they would be to add on to the conversation that I think began a little bit with regard to the separation of powers case from many years ago, the McCrory v. Berger case that Senator Berger brought up. The governor seems to be suggesting that there will be litigation over the appointment authority in some of the acts recently of the General Assembly. And I do think it is wise to go back and be up to speed on those cases from years ago because we may get to revisit them. So that's my take. Nick?
Thanks. Well, thanks so much for having me. I'm going to talk about 3 cases from 2022, a case about medical malpractice, a case about civil procedure, and a case about criminal law. The 3 cases really don't have anything to do with each other as a matter of substance, but I'm going to try to convince you as I go through these cases that actually there are some common themes and threads that are running through them that might tell us something important about where the court was in 2022 and where it might be going for the rest of the year and into 2024. So I'm going to start with the medical malpractice case. This case is called Connett against Charlotte Mecklenburg Hospital Authority. The case arose out of the catastrophic injuries suffered by a young child as a result of, allegedly as a result of the implementation of a negligent anesthesia plan. This is a very factually and procedurally complicated case. So I'm just going to focus on one aspect of it, which is the child's parents and guardian ad litem suit against the certified registered nurse anesthetist. And that is a word I have practiced saying many times. I'm not going to say it again. I'm going to call that person the CRNA. And whether the CRNA could be held liable in tort, despite the fact that the CRNA collaborated with and performed this anesthesia plan under the supervision of a licensed physician in North Carolina. The plaintiffs in the trial court asked the trial judge to introduce evidence about the standard of care for CRNAs, but the trial judge excluded that evidence, citing to a 1932 decision of the North Carolina Supreme Court called Byrd. That decision held, with a few exceptions that aren't relevant here, that a nurse does not owe a duty of care to a patient in the diagnosis and treatment of medicine when the nurse is working under the supervision of a licensed physician. And the plaintiff had argued in part to the Supreme Court that it should overrule this 90-year-old decision about medical malpractice liability for nurses. There's an added wrinkle in this case, which I'll come back to in just a bit, which is that 2 justices were recused. So this was a 5-justice court deciding this question. 3 justices voted to overrule Byrd, Justice Morgan, Hudson, and Earls. And they gave 2 main reasons for why they were deciding to overrule this very long-standing case. The first, and as I understood it, sort of the most important of the reasons, is that the world has just changed since 1932. So the role that nurses play today is very different than the role that nurses played in the 30s. Nurses are increasingly regulated. They play increasingly important roles, independent roles in the provision of healthcare services. And so the majority thought that, look, this rule is just kind of outdated. Nurses are no longer sort of under the thumb of physicians. They may make independent judgments, and so therefore should have an independent duty of care to the patients that they take care of. The majority also cited a bunch of statutes and regulations that, in its view, supported this idea that the practice of medicine in the state had sufficiently evolved such that Byrd should be overruled. The second big reason that I see in this 3-justice opinion for overruling Byrd is what it calls the silence of the General Assembly. So the 3 justices say, look, the General Assembly hasn't really done anything to change the Byrd rule or abrogate the Byrd rule. And so, this is a rule that we created, and therefore it really falls to us to decide to overrule it or change it or update it. There was a dissent, Justice Barringer joined by the Chief Justice, who said that, look, Byrd is a very clear rule. It's a very long-standing rule. It's pretty much a bright line rule that gives medical professionals a lot of certainty in how they should be conducting their affairs. And really, it's the role of the General Assembly, not the role of the court, to be overruling Byrd if the General Assembly is of the view that this rule has somehow become outdated. The General Assembly, after all, makes policy, and this is the kind of policy decision about the regulation of the healthcare field that really should be left up to them. Justice Barringer's dissent also raised a number of questions about, well, sort of how is this going to work in practice? Like what happens, for example, if a CRNA and a physician disagree about a particular anesthesia plan? Like who should be liable in that circumstance? How should their conduct proceed if they see things differently? So I see sort of 3 big themes coming out of this case that I'm going to try to also highlight in the next 2 cases. One is a divide on the court between justices who prefer clear, bright line rules and those justices who prefer standards that are more informed by underlying purposes or resort to considerations of fairness or equality or access to justice. So you can see this very clearly in the 3-2 decision here. The dissent thinks that Byrd is a very clear, pretty bright line rule that gives people a predictable way of sort of organizing their affairs, whereas the 3-justice majority looks at Byrd and says, this rule is kind of outdated, it's outlived its underlying purposes, it really sort of falls to us to be the ones to update it. A related point along this line is a difference, just sort of a very fundamental difference in sort of the role of the court. Does the role of the court is it a broad role? Is it a sort of a more muscular role with respect to other institutions in our society? Or is it a narrower role, a more circumscribed role? Again, the dissent says this is up to the General Assembly to fix, whereas the majority or the 3 justices who decided to overrule Byrd think that it really is something that falls to the court. The final point that I'll just mention briefly is a point about stare decisis. So the majority on the court does not run through what I would think of as sort of a formal stare decisis analysis for why it is overruling this 90-year-old decision. The dissenting opinion says Byrd has full stare decisis effect and should be a decision that we stand by. This issue, I'll just sort of footnote one sort of final development in this case, is that this issue about stare decisis actually is now again before the court. So I'll gloss over a lot of complicated procedure, but the case went back to the trial court, and now the hospital authority is back in the state appellate courts arguing that in fact, 3 justices do not have the power to overrule a decision of the North Carolina Supreme Court, that in fact you need 4 justices or a majority of the court in order to overturn a prior state high court precedent. The court has not acted on that petition, so stay tuned. The next case that I'm going to talk about is a civil procedure case called M.E. versus T.J. This is a case that had a very interesting constitutional question in it, but actually became kind of a Civ Pro law exam given some complicated procedures that took place. So I'll briefly recount the facts, which are also quite complicated. The plaintiff was in a same-sex relationship and alleged abuse by her partner. She went to a local courthouse seeking a domestic violence protective order. She was not represented by counsel at the time. The clerk's office provided her with some forms to fill out that would allow her to seek a protective order of this kind. One of those forms is called a Chapter 50B protective order. Chapter 50B, however, limits protective orders to only those couples of opposite sex who live together or who have lived together in the past. And so learning this, the plaintiff said, well, this doesn't apply to me. I want to dismiss the rule, the Chapter 50B complaint that I have filed. And so that's what she did. She filed a notice of voluntary dismissal. This is all happening sort of on the same afternoon, and decided to seek a different kind of protective order that she actually could receive under the terms of the statute. About 40 minutes after she voluntarily dismissed the Chapter 50B case, she changed her mind and hand wrote on the notice of voluntary dismissal that she had filed, quote, "I strike through this voluntary dismissal. I do not want to dismiss this action." So the case went before a trial court. Hearings were held. There were arguments about the constitutionality of the sex-based classification in Chapter 50B. This case ends up before the Court of Appeals, where a majority on the Court of Appeals holds that Chapter 50B is unconstitutional under various state and federal constitutional theories. There's a dissent in the Court of Appeals, though, that focuses solely on the various procedural aspects of the case, including this notice of voluntary dismissal and the plaintiff's subsequent decision to kind of take it back by writing on it that she didn't really mean to file it. That's the question, that procedural question, that ends up before the court. This is a 4-3 decision. Justice Hudson writes the majority opinion. Justice Berger writes the dissenting opinion. And the court holds that the plaintiff's decision to file a notice of voluntary dismissal and then subsequently withdraw that notice did not deprive the trial court of jurisdiction to rule on the constitutionality of the statute, the main issue that the Court of Appeals below had addressed. The court reasoned that the withdrawal of the notice of voluntary dismissal was the functional equivalent of a Rule 60B motion. And Rule 60B allows a court to relieve a party from a final judgment, order, or proceeding for mistake, inadvertence, surprise, or excusable neglect. The majority explains that maybe it would have been preferable for the plaintiff in this case to have simply refiled a new Chapter 50B action or to have filed a formal Rule 60B motion. But the court says that would elevate form over substance. The court pays a lot of attention to the fact that this plaintiff was a pro se plaintiff seeking relief from allegations of domestic violence. The court holds that in this context, procedural rules should not erect hurdles to being able to access civil justice. The dissent basically says, read the rules. So the dissent says, look, the minute that you file a notice of voluntary dismissal, the trial judge loses jurisdiction to do anything else. And if you had wanted to try to sort of take back the notice of voluntary dismissal, what you should have done is file a formal Rule 60B motion, right? The dissent argues that the rules really don't recognize like the functional equivalent of a Rule 60B motion. That's actually something that you would have needed to have filed. And And then the dissent also points out that Rule 60B only allows relief from a final judgment, order, or proceeding, which really doesn't seem to describe a notice of voluntary dismissal at all. So again, just coming back to my themes real briefly, I mean, this is a classic rules versus standards case, right? So the dissent is very focused on the clear, plain rules in the rules of civil procedure and following those rules even in a case where, as here, the plaintiff was not represented by counsel when all of these procedural complications arose. The majority, by contrast, says, and I'm going to quote here, North Carolina courts have abided by the foundational principle that administering equity and justice prohibits the elevation of form over substance. I think there's also a little bit of a hint of a divide between sort of deference and the broader role of the court. The majority says, for example, that its decision is actually furthering statutes passed by the General Assembly that have tried to make it easier and more accessible for victims of domestic violence to access the courts and file suits seeking domestic restraining orders of this kind. The dissent, by contrast, says it's really not our role. We need to stick to the text of the relevant rules. Okay, I'll do one final case briefly on the criminal side of the docket. And I was involved in this case, so just take that as a caveat. This case is called State against Tripp. This is a really interesting Fourth Amendment case from last year. The facts are pretty straightforward. There was a warrant issued for a residence where police had probable cause to believe that narcotics were being sold. When the police went to execute the warrant, the defendant, who was the target of the investigation, but who was not named in the warrant, was standing not on the property where the warrant was executed, but right up against the house next door, about 50 to 60 yards away. The police officer who arrived on the scene had interacted with this defendant before with respect to various firearms-related offenses, goes straight up to the defendant, who was not doing anything at the time, it was undisputed, detains him, frisks him for weapons, and finds heroin laced with fentanyl in his pants pocket. And the question is the heroin suppressed under the Fourth Amendment? The court splits 3-1-3 in a plurality opinion written by Justice Berger, joined by the Chief Justice and Justice Ervin. The court says that there was no Fourth Amendment violation. The detention was permissible. And that's because when you have a warrant for a piece of property, the warrant carries with it the implicit authority to detain individuals who are within the vicinity of that property to make sure that the execution of the warrant is safe and efficient. There was a concurring opinion by Justice Beringer that did not join this particular discussion of this aspect of Fourth Amendment doctrine, and instead would have resolved the case on sort of more familiar grounds about reasonable suspicion. So as I mentioned before, the police in this case had had prior interactions with this defendant involving firearms-related offenses, and so I think the theory goes, perhaps they had reasonable suspicion on that sort of independent basis. The dissent, and I know I'm running up against time, so I'll be quick. The dissent says, look, this is a really close case. It's a really hard case. But it's actually the dissent in this case that really leans into a very bright line rule. The dissent says it's all about the property. The defendant in this case was not on the property where the warrant was being executed. He was on the other side of this invisible property line. And therefore, under the Fourth Amendment, it was impermissible for the officers to go up to him without any kind of reasonable suspicion or other type of probable cause to effect a search of his person. So those are three cases from 2022, certainly not high-profile cases, but hopefully I've convinced you that there are some important themes that are running through all three of them. Thanks.
And I'm going to go last, and I'm the only person stopping you from getting out of this room, I guess. But most of the cases we've talked about today are mostly backward-looking, and I want to talk only about forward-looking cases. There's no SCOTUS blog to track cases at the North Carolina Supreme Court. So if you're like me, sometimes you can be surprised when an opinion comes down and you didn't even know the issue was pending up at the court. So all the cases I'm going to talk about are at various different procedural postures. Some are at the PDR stage, some are being briefed on the merits, and some have already been argued, and we're just waiting on an opinion. I first want to talk about a variety of interesting cases at the court involving COVID. If you're like me, COVID's starting to become a little more of a distant thought. But the COVID cases are actually just now hitting our Supreme Court. One of the interesting cases that definitely be of interest to the small business community is North State Deli versus Cincinnati Insurance Company. In that case, a group of restaurants have sued their insurers for denying business interruption claims. Of course, this is not completely unique litigation. It's litigation that's happening all across the country. And they're saying that the claims should have been paid out because of the COVID and government shutdown orders. In this case, the Court of Appeals unanimously held that there was no coverage, and now the insured restaurants are seeking discretionary review at the Supreme Court. And because the policy language is pretty similar across insurers, and given the number of affected businesses in North Carolina, I wouldn't be surprised if we saw a discretionary review granted in this case. I would imagine the cases will keep coming if review is not allowed in this one. The other two COVID cases involve refund claims filed as class actions against the UNC system. In the early days of the pandemic, the General Assembly immunized universities for claims for refunds and fees paid during the 2020 spring semester. And in one case called House versus Board of Governors, a class action is seeking a refund of those very fees that have been immunized by the legislation. And the claim there is that the legislation itself is a violation of various provisions of the state and federal constitutions. A PDR is pending in that case because it was a unanimous decision from the Court of Appeals. But in a different case called Lannon versus Board of Governors, a class action is seeking a refund of fees paid in the fall 2020 semester when there was no immunity legislation in place. Long ago, our Supreme Court held that when the state enters into an express contract, it waives sovereign immunity. But the refund claim in this case is not really an express contract. It's what we called contract implied in fact. And a contract implied in fact is still a real contract. It has offer and acceptance, but we really are implying the offer and the acceptance based on conduct. And in this case, the state is saying, well, that's not good enough to waive sovereign immunity because it's not a true voluntary act. The Court of Appeals held that the state waives its sovereign immunity in fact for implied in fact contracts, and the Supreme Court granted discretionary review, and briefing is underway in that case. The next two cases involve state constitutional challenges to shutdown orders that were issued in 2020. In the first case, Howe versus Cooper, a group of restaurants have sued challenging the constitutionality of the governor's shutdown orders. The constitutional claims ask whether the shutdown orders violate the state constitutional rights to earn a living under the fruits of the labor clause, or the state law of the land clause, which is our state constitution's equivalent of the due process clause in the federal constitution. And the other question that's been injected in the case by the Solicitor General's office is a very interesting question. And the question is, if there was a constitutional violation, are the plaintiffs really entitled to damages, or are they really just stuck with injunctive relief? Of course, injunctive relief is no relief at all because the shutdown orders have now been lifted, so that would be the end of the case. The Court of Appeals majority held that the complaint stated a violation, but Judge Arrowood dissented. The state has appealed to the Supreme Court based on the dissent, but there's a PDR on the additional issue of the injunctive relief. The other case is an even more spicier COVID case, Kinsley versus Ace Speedway. And we might see a PDR in the Howe versus Cooper case get held until the Supreme Court decides what to do with the Ace Speedway case. This is very similar. When the governor issued his shutdown orders, Ace Speedway essentially defied the orders and kept holding races. It's racetrack. DHHS sued to stop the Speedway, and an injunction was in fact issued against the Speedway. But the Speedway then counterclaimed under the state constitution, alleging selective enforcement of the laws and a violation of the racetrack's right to earn a living under the state constitution. And in this case, the racetrack is seeking damages, again, for both of these constitutional violations. The Court of Appeals unanimously held that the racetrack pleaded its constitutional violations appropriately, and the case is now at our Supreme Court. The state is seeking dismissal of the constitutional claims, and like in Howell, the state is arguing that the racetrack should be limited just to injunctive relief rather than damages. The Supreme Court has set this case for oral argument next month. Next, I want to talk about Leandro. I'm not sure if it's part 4 or part 5 or part 6, or if it's supposed to be called Hope County at this point. But in 2022, this will be no surprise to anyone in this room, the Supreme Court in a 4-3 decision held that the judiciary could order that funds be transferred from the state treasury to fund public schools based on a violation of the state constitution's guarantee of an adequate public education. The court then remanded the case to the trial court to determine how much money should be transferred out of the treasury. After the trial court set an amount at $667 million, the legislature appealed to the Court of Appeals. And now that the case is there, the legislature has filed a bypass petition, like Martin was talking about earlier, seeking to bypass the Court of Appeals, take the case right back up to the Supreme Court. And they're doing that because they're asking the Supreme Court to overturn the 2022 decision and have the court hold that the judiciary, in fact, cannot order this transfer of funds. And although it might not seem like it at first, I think that there is a similar separation of powers issue going on both in the Leandro decision here and in the government shutdown cases. Because really at their core, the question is whether a money judgment can be enforced against the state. In Leandro, the court said it could force the state treasury to pay such a judgment. And in the COVID shutdown cases, the state is arguing that the state can't be liable for money damages for those constitutional violations. And so both cases really pose the question of whether the judiciary can order the state to pay money out of the state's coffers, without approval from the General Assembly. And I think that's an important and a difficult separation of powers question that is coming to a head in our state Supreme Court. The next are a variety of interesting cases involving kids and statutes of limitations and the Constitution. In 2019, the General Assembly enacted what's often called the Safe Child Act. That act temporarily revived claims that had become barred by the statute of limitations for adults who, when they were children, had been sexually abused. That law spawned lots of litigation all across the state, and in particular against institutions that had employed abusers, such as public schools and civic organizations like the Boy Scouts. In Cohane versus Home Missioners, the question is whether, as a matter of interpreting the Safe Child Act, the claims against employing institutions have been revived, or whether the revival only applies to the abusers themselves. The other case is more complicated constitutional question in McKinney versus Goins. In that case, a local school board, public school board, is arguing that it has a state constitutional right under our law of the land clause not to have claims against it revived once they have become barred under the statute of limitations. Now, this claim is just being brought under the state constitution because, as a matter of federal law, there is no vested right in a statute of limitations defense. And our state constitution, interestingly, does talk about ex post facto laws, but only expressly bans criminal ex post facto laws. As in Cohane, the Court of Appeals sided with the student victims in a split decision. And just as a matter of full disclosure, I filed an amicus brief myself in the McKinney case, supporting the student victims, arguing that the law of the land clause only protects people, not the government. Expect both cases to be appealed to the Supreme Court. I think there's already been a notice of appeal filed based on a dissent in one case, and I think the other one is due very shortly. The opposite type of legislation is being litigated in a case called Morris versus Rodberg. As we all know, when kids are injured, their claims are tolled until they turn 18. But in 2011, the legislature required that some minors bring their medical malpractice claims before they turn 18. And so this case turns on the child's argument that the early accrual of his claim without tolling while he was still a child violates the state and federal constitutions. Oral argument was heard last month, so we could probably expect a decision in that case over the next several months. Last, I want to talk about a hodgepodge of state con law claims that raise unique questions under our state constitution. Recently, the court granted discretionary review to determine the constitutionality of the state certificate of need law. Now, that law is itself pretty complicated, but at its core, it says that the state is going to create a plan every year or so, and it's going to determine all the medical needs for the entire state. Services like MRI machines. And if you want to own and operate an MRI machine, you're going to need a certificate of need to do so. The state grants those certificates to healthcare providers so that the exact amount of predicted services and no more than that are provided across the state. And the court struck down the CON law many decades ago, holding that it violates the state's anti-monopoly clause. But it was since modified and reenacted by the legislature and has been on the books and actively enforced ever since. In Singleton versus DHHS, the court will decide whether this statutory scheme, even as modified, violates various provisions of the state constitution. And again, a disclosure, our firm represents some amici who are defending the law's constitutionality. Last, I want to mention a case involving a fired UNC professor that's also headed to our state Supreme Court. Part of Mitchell versus Board of Governors is a First Amendment challenge, asking whether the professor's comments about race and academia were matters of public concern, and thus protected speech for which he couldn't be fired. Again, I know I represent Professor Mitchell in this appeal, but the other question in the case is one that we have talked about several times already today. It's a question of agency deference. When agencies write ambiguous rules, should courts defer to the agency's interpretation of the rule, or should courts decide the best reading for themselves? Historically, our courts have deferred, especially at the Court of Appeals, which is what happened in this case. This case asks whether deferral can really be squared with the court's duty to say what the law is. The U.S. Supreme Court cut back on this type of deference, which is called our deference, a few years ago. The court was one vote shy of jettisoning it altogether. And now our Supreme Court will have the opportunity to decide what the deference law will be in our state going forward.
Thank you. Cognizant of the fact that we are what's standing between everyone else in the cocktail hour, I do want to give everyone a little bit of opportunity if there are any comments or thoughts you have on something someone else presented today.
It was a good job all around.
Yeah, great job. Great job. Obviously, very cleared up every issue about everything. Let me ask, for a long time in North Carolina, if you had a dissent on the Court of Appeals, you got an automatic right of appeal to the Supreme Court. That has recently changed. I didn't know if you had thought on how that may impact appellate practice in North Carolina.
I mean, I would love to see some kind of empirical study done on this in a year or two to see what effect, if any, the elimination of dissent-based appeals actually has. I suspect that now that appeals will only be heard through the PDR process, that anytime you get a dissent, one of the very first things you would say in your PDR is, I got a dissent. So as a practical matter, I'm honestly not sure it will make a huge difference. But Troy might have different views on that.
I have mixed feelings. I think it's a little bittersweet as an appellate practitioner. It's nice when we had dissent-based appeals because reach out to the client, here we go. We're going to the Supreme Court. You have a right of appeal. But I can also understand the concern of why are we letting essentially a minority of Court of Appeals judges decide the docket of the Supreme Court. That doesn't really make a lot of sense. But what I do think would be really helpful to lawyers and appellate practitioners is guidance from the Supreme Court about what issues they want to hear about. At the U.S. Supreme Court, there's a lot of concurring opinions, dissenting opinions, sort of forecasting, highlighting issues that, the issue doesn't quite come up in this case, or it wasn't the right vehicle for us to address it here. But Justice Thomas, for example, saying, "I would like to see a case, involving this kind of issue. This is an issue that's important to me, but this case just isn't the right vehicle for resolving it." I think it'd be really helpful for attorneys to see more of those sort of separate kinds of opinions from justices, so that we can give them what they would like to see and what let them develop the law in places where they think it needs that kind of development.
I mean, this is, I think, a challenge that we all share, which is that the statutory PDR factors are just as broad can be. That's like, is the case important? And that's obviously in the eye of the beholder, right? And so I have to imagine that the justices and their law clerks struggle with this all the time. And so it's a process that for lawyers, we just don't have a whole lot of insight into, and is now, with the elimination of dissent-based appeals, going to become increasingly important to the court's work.
So that's a good law review topic for any law students who are in the
Absolutely.
room, or any aspiring
Absolutely.
professors to do that work that Nick has suggested. I think we have time for probably one brief question for the panel to answer. So if anyone has a question, I want you to raise your hand. One of our students, the microphone will take it around. Gentleman in the back.
Yeah, thank you for that presentation. I want to just follow up on the last points that y'all were making. We focus on sort of the effect of eliminating dissent-based review at the North Carolina Supreme Court and the effect that'll have on the Supreme Court. What effect do you think that'll have on the Court of Appeals?
I don't know. You might think it will cause less dissents, right? Because we used to jokingly say, well, the Court of Appeals is certifying the case to the Supreme Court by dissenting. But I could also imagine some of the judges feeling a little freer to dissent. They might think, well, I'm not forcing the court to take a case that they don't want to. So I might feel a little freer to say, what I really think about this issue, how I think the law ought to be. And whether that's called a dissent or whether that's going to be called a concurrence, I don't know. It might depend on the case. But I could see it going either way.
I agree with that.
I would add real quick. I thought about that it might cut down on the number of dissents, but there are so many other courts where the dissent does not drive it to another particular review, and the jurists still dissent. And I think particularly here in North Carolina, where all the jurists are elected, it is an opportunity for you to write how you feel about a particular issue, and that may still influence people to dissent. And like Troy said, maybe even more so, because you're not making work for someone else, you're just putting your view out there.
Great. Well, please join me in thanking our panel.